Welcome back to Our Issues Birmingham. I am delighted today to have a good friend and colleague, Judge Shantae Owens, Jefferson County District Court. How are you, Judge?
I am doing great. Thank you for having me.
Oh, yeah, I've looked forward to this day. I wanted to have you before the election. However, you were busy doing election things.
I was.
And she did win, and she will be our judge for the next
6 years.
6 years. That means you're pretty much locked in now.
I am. Y'all have me for another 6 years at least.
Well, you do a great job in there.
Thank you.
So, Judge Owens runs the drug court. And the drug court started back in the late 90s when I was a baby lawyer. And I will tell you, I know you were still in law school back then.
Actually, I was in college back
Really?
then. Yes, I wasn't even in law
These
school
are scars, not wrinkles. Really?
I was in college, in undergrad.
Just a baby.
Because it started in 1996.
Well, I remember the big hang-up was the lack of adversarial nature of a drug court. And that was the hang-up with the defense bar, people like me, because, you know, we had to, like, volunteer for drug testing, and the Fifth Amendment issues became, well, we're incriminating ourselves even though they don't apply. But tell us what the concept is behind drug court and how it started, if you know, and what you actually do there.
Okay. As I said, drug court started in 1996 under the leadership of Judge Pete Johnson. And drug court started as a way to provide rehabilitation services through the criminal justice system for those nonviolent offenders who were charged with drug offenses, low-level offenses, not distribution, trafficking, or manufacturing cases, but just possession cases. It has grown greatly during that time from 1996 now through the present. And what we are still doing the same thing that drug court set out to do in 1996, except for that we have added a lot of things to just make the program better. We now have individualized assessments for our clients in drug court so that we can determine how to better treat the addict, because no addict is alike. There is a great difference between the pot smoker and an IV heroin drug user, and we try our best to treat everyone individually through drug court.
Yeah, that's always been a beef of mine, because you can't really pigeonhole all drug users as all the same.
Absolutely.
You have your
You're
recreational
right.
pot smokers or cocaine users, and then you, as you say, you have the IV drug users, and that means they're sticking needles in their arms. People don't know what IV means. I will go ahead and mention this. I know we didn't plan to talk about this, but when you speak of distribution, you know, you have drug distributors, but you also have some very low-level marijuana distribution cases that are essentially people acquiring pot because it's cheaper by the dozen and sharing it with their friends. Has anyone ever thought about maybe looking at those cases not quite as harshly as you would some other distribution case?
You know, I can tell you that I don't believe the district attorney's office will look at that differently.
I think that's a safe thing to say.
I think the district attorney's office will look at distribution of a controlled substance as distribution of a controlled substance, and they will treat marijuana as they will treat any other drug. I tell defendants all the time, I tell them, I know y'all don't believe it, but marijuana is illegal in the state of Alabama,
Correct.
And I must punish it as such. However, I cannot sit here and tell you that I won't take into account that it is marijuana versus heroin. I will take that into account. Doesn't mean that the defendant will not be punished, but there are some things that will be taken into account when sentencing if a defendant is sentenced before me, if it is marijuana versus heroin.
You may or may not know this, but recently it has been noted in the press that marijuana can now be smoked and possessed legally on Indian reservations.
Wow, I did not know that.
So I'm wondering, are we all going to start seeing people going to Wetumpka and Atmore?
I think we will.
Oh, yeah.
I think we will.
Yeah.
I did not know that.
Yeah.
No, I didn't know that.
Well, it's brand new. So, and it seemed to have come in darkness and get blessed in darkness. So we're getting a lot of conflict between federal law and state law, particularly as it relates to marijuana. Now, the concept of drug court is more public health oriented, I would say, than criminal procedure, criminal justice
Oh, yes.
oriented.
Yes. And I think that is something that some of the attorneys have to get used to, because sometimes the defense attorney may want to fight about something, or even the prosecution may want to fight about something. And the goal of drug court is it is non-adversarial, and it is, we all have one goal, and that's to treat the addict. And the defense attorney can represent their client to the fullest extent, but they also have to understand that we will always make decisions that are to aid the client in living a clean and sober lifestyle. So there are times for drug court where a defense attorney has to stand silent so that I can take a person into custody so that they can get the help that they need. And that's a little hard for some people to understand. But drug court is a different model than just your regular model in the criminal justice system.
I know that there are intermediate sanctions that are imposed upon people who do things that violate the terms of their drug court agreement. So what I think that people should understand is that drug court is primarily, well, exclusively for drug users. You don't allow anyone with any violence or guns or anything like that.
No history of violence. You cannot have a history of violence. You cannot have a weapon during the commission of an offense. You cannot even have a prior conviction for a gun charge, because we are trying to isolate nonviolent offenders, and we are also trying to isolate the addict, which is why we will not even entertain a drug distribution, trafficking, or manufacturing charge in drug court.
Well, hold that thought. We're going to talk about the specifics of how it actually works when we come back from break. Don't go away. This is Our Issues Birmingham. We'll be right back. Welcome back to Our Issues Birmingham. Judge Shantae Owens is with us. We're talking about drug court and how drug court works. So let's walk the people at home through, well, I can tell you what happens on my end. I get a phone call and, you know, they need to know how to make bond, and I get them through the bonding process. And then one day these drug possession cases, all of which go to you.
Yes, all in the Birmingham division of the county.
Yes, they will go to Judge Owens' court, and these individuals come before you. What is the assessment process that goes on with the DA? Aren't they the ones that make the recommendation?
They are, because the DA's office has to look at the facts of the case, determine, make sure that there are no evidence of sales, because if a defendant is caught possessing scales or anything that would lead to evidence of sales, then the DA's office will probably not offer, make a drug court offer. They have to talk to the detective in the case to make sure that the detective is okay and doesn't have anything to say about evidence of sales.
Well, here's the defense lawyer in me. You know, if you're buying marijuana or something that you are buying by what it weighs, you're not necessarily selling because you have scales. You may be just trying to not get ripped off.
And that is the argument that they make.
You mean
so
someone
very
other
often.
than me thought of that?
They probably heard you make the argument, but I tell you, I hear that all the time from the defendants, and I tell them that drug court is it is a pretrial diversion program. The DA's office has to agree to drug court, so it is not something that even the judge can just override, because the DA's office is not a right to drug court; it's a privilege, and so they have to agree to it. But luckily, we have had very good prosecutors in drug court who have understood what drug court is about, and they've also understood the help that drug court provides to the community. And I think they've done a great job with isolating the drug sellers versus the drug users.
And the discretion of whether or not to allow someone in is solely the DA's office.
Well, no, it is actually between the court, myself, and the DA's office.
Do y'all do some staffing kind of meeting about it?
We do. We actually have a staffing meeting, but in my staffing meetings, the DA's office is not involved in the staffing meeting. But I have a staffing meeting for a different purpose. But what I do, the DA's office will make recommendations of drug court. If a defense attorney feels as if their client should have been offered drug court, then they will speak to me, and then we'll all speak together, me, that defense attorney, and the district attorney, and the DA. And we will usually hash it out there. Afterwards, once someone makes application into drug court, I review the files individually, because sometimes there are things that the DA's office, they can't catch or they don't catch because it is not on their criminal history sheet. There are times that I will see where the defendant has a violent federal crime on his criminal history sheet, and they're denied drug court, whereas the DA's office for some reason may have missed that. So there is there is a meeting that we may have together, and then I go back, just as a safe procedure to try to make sure that we are getting the right client. And after that is done, then the client comes in and pleads guilty into the drug court program. And on that date, we explain the rules of drug court. We explain all that is required. Clients must come to court depending on where they fall in the assessment. They must be randomly tested for drugs, and drug court is divided up into 4 tracks depending on where you fall in that assessment. It can either be a 3-month program for you, a 6-month program, 9 months, or 12 months. If a client tests positive while in drug court, then they are sanctioned for that. They come to court on Thursdays and they are sanctioned. And that sanction can be anything from community service to writing an essay to giving a speech to jail time, which is the most widely used sanction because that's the one that will get everyone's attention.
Fear is a great motivator.
Oh, it
in
is.
Most,
it
in
is.
most things.
And case managers, they make treatment referrals. It is really a huge operation that goes on because we have a treatment coordinator, case managers, and a drug court administrator.
And is this done in conjunction with UAB?
It is with UAB Task,
Which is the Department of Psychiatry's
Yes.
component that does all the drug and alcohol testing for Jefferson County, and
for all of Jefferson County, and I'm not sure. I believe they do some in Shelby County also, but I'm not sure.
Yeah, they're very overworked and understaffed.
They are.
And I would assume you have a huge volume of attendees in your court.
I do. Because drug crimes are the most populated crimes. I think that my courtroom probably has the most amount of cases coming through there. I've presided over more than about 30,000 cases since my time on the bench. Now, that doesn't mean everyone goes into drug court because I do more than just drug court. I have a regular docket and drug court. But, you have to remember that even if you're arrested with a Loratab, that is a felony drug crime if you don't have a prescription for it. So,
And what folks need to understand is you plead guilty to the offense, and it's part of the catharsis, I guess is the word, where you accept responsibility for what you've done. But, Judge, this is some legal mumbo-jumbo, but the judge never finds you guilty.
That's right.
So there would never be a trial. You just sort of hang this guilty plea out over your head.
That's right.
And if you successfully complete the program,
then I will enter an order dismissing the case if you complete the program. And you will also have to pay your drug court fees, which are nominal fees. You'll have to perform community service. And if you have not completed high school, you must get your GED, skill, or trade. Because what we're attempting to do in drug court is not a quick fix, but a total lifestyle makeover.
And when I was getting going with drug court in the late 90s, and as Judge Johnson was moving along, I believe there was close to an 80% success rate.
Yes, and
Is that still maintained?
We still maintain that. It may be a little less now. I believe our success rate is somewhere around 75%, and 75% of those people never come back to the criminal justice system.
75% of the 75%? Is that what we're saying?
Yes, that's what we're saying. Yes, they never come back into the criminal justice system. They don't pick up new cases.
Oh, that's great. That's a
Yeah.
tremendous success rate, and
Yeah.
I would assume that's, well, certainly for the individual, it keeps them without having a felony conviction.
Yes.
And under Alabama's new state of affairs there, we are eligible for expungement and things of that nature.
Yes.
We're going to take a break.
Okay.
Don't leave me. Please
will
promise me.
not.
We'll be right back. This is Our Issues Birmingham, and we're going to talk about the bad things about drug court next. We've talked about the good things. We'll go somewhere else with it in just a minute. Don't go away. Welcome back to Our Issues Birmingham. Judge Shante Owens is with us, and we're talking about drug court. I think it's important, we talked about it at break, whether you know it or not, as disconnected as this may seem, if you are convicted of a drug offense in Alabama, you lose your license for a period of 6 months.
Yes.
That does not happen in a drug court disposition.
No, it does not.
And Alabama has no hardship license.
No.
Because we haven't, and I wish some legislature that might be listening might consider that, but how do these people function? Because you want them to be working.
Yes.
Impossible to get a job without a license. Not
That's
impossible, but very difficult.
It is very difficult.
So aside from offering the drug treatment, I call them modalities that y'all go through, isn't there other social programs that you offer through the Department of Psychiatry at UAB to help these people find jobs and maybe
Yes,
get them placed? And
we
things?
do. We actually, on our drug court team, we actually have a jobs treatment coordinator who helps with resume writing and to help find jobs. Because we are really trying to get everyone employed. Everyone that can be employed, we want them to be employed in drug court. And going back to the license suspension, what you stated, the great thing about drug court is that the license suspension is stayed. Your license is not suspended as long as you complete drug court. But if I have to place your conviction into effect, if you do not complete the drug court program, then there is a 6-month license suspension. And the sad thing about that is that there is so much that I order, that I have to order upon a conviction being placed into effect. You must pay lots of fines, fees. You must report to the probation office. You must report to several classes. And I often have defendants who will ask me, well, Judge, how can I do all that? And you just suspended my license. And I have to tell them, I don't think it makes any sense at all, but it is the law. So it just happens.
What are the costs involved in participating in drug court? Range of money.
It can range anywhere from about a little under $400 to about maybe $900, depending on where you fall in your treatment assessment, because track 1 is less expensive because it is only a 3-month program, and it goes up to track 4. And track 4 may be around $1,000 or so, but you don't pay that all at once. You actually, I'm very understanding towards fees, just as long as the defendants are attempting to pay something. If you are on disability, you do not pay the normal schedule of fees. You pay a very reduced rate of fees. And the fees are really just an attempt to rehabilitate the defendant into being responsible. It is not for us to make any money off of drug court, but so that they will understand the responsibility of life.
So it helps kind of pay for itself, really,
Yes.
in some ways. Now, what about the indigent individuals who have no money? Are they still required to try to scratch up some money somewhere?
Well, they are. They are required because we want even the indigent individual to get a job. However, I am, and I say this again, I'm extremely understanding when people are not able to pay fees. I tell them all the time, what I want more than anything is I want them to show up to test, I want them to go to treatment, and I want them to live a clean and sober lifestyle. I am not so concerned about the money aspect of it. There are lots of cases where I've remitted the fees, meaning that they did not have to pay their fees as long as they were clean and sober and doing well. But if they can work, we want them to work, and we want them to pay their fees.
Well, we've talked about some of the great things that come out of drug court, and I will say it is a great program, and we do a good job with it here, and you do a good job with it particularly. But what are the downsides? We end up with some people that don't do so well.
Yeah, we do. We end up with people who, after a lengthy amount of time in drug court,
So you don't
they
throw
just can't shake
you
it.
don't throw the key away upon the first misstep.
Oh no, addiction is not an exact science, and so I am extremely patient with addicts, and I tell them that I will not sentence them out of drug court simply for relapsing, but they must work the program. They must try, and if they relapse, there will be consequences to it. But I will continue to work with them in drug court. But if I have someone that is not coming to court, will not go to treatment, they're not testing, they're not doing anything, then there comes a point in time where I have to sentence them out. And if I feel that they're a danger to themselves or to the public, then I will send them to the penitentiary on their case. But there are lots of things that I do with sentencing. I can sentence them to community corrections, to probation, or to the penitentiary. And I use all of those services.
Have we had some unusual, funny things that have occurred in the testing world where people try to beat the system?
Oh, yes. Yes, we
And
have.
I know about the fake penis.
Oh, yeah. I mean, they bring in devices and they bring in urine from days ago. And I tell them urine has to register at a certain temperature. And if it doesn't, then we know that it did not come from your body. And that is the one unforgivable sin of drug court. I tell them there is only one thing that will get you automatically sent to prison, and that is manipulating a drug specimen if they dilute their specimen or if they bring in a device or anything.
So even in my court, I tell people, listen, I'm going to test you. I want to know the truth. If you're clean, say so. If you're dirty, say so.
That's right.
The worst thing you can do is lie.
That's right.
But they lie.
They lie. They do.
It's amazing to me. I'm not trying to judge
It's
you.
addict behavior. Yeah, it's
Is that what
addict
that is?
behavior. Yeah.
The reason I mentioned that, there's a device on the market called the Whizzinator.
The Whizzinator.
Yeah.
Yes.
Google it. You too can have a Whizzinator.
Please don't. Yeah, plenty of people have gone to prison and drug court for the Whizzinator.
Really?
And I tell them from the bench, do not bring a Whizzinator in here because you are being watched when you test and you will go to prison.
Yeah, it brings up a whole nother world. Watched while you use the bathroom there. Okay. It's time to stop. Thank you for joining us today,
Thank you
Judge.
for
This
having
has been
me.
a great show. Our Issues Birmingham. We will see you next week.
Beautiful.
Yay.